Zane Bury. Is that you?
Yes, sir.
You still carrying around a drug patch?
Yes, sir.
Uh-huh. How often do they collect the drug patch and test?
See, in the beginning, they didn't test it on like.
How long? I'm just asking.
I honestly don't know, sir.
Well, I mean, don't they take the patch off of you?
Yes, sir. Well, I get it.
Don't you know when that happens, or are you
Yes, sir.
asleep?
I thought you were asking me when they tested.
No, I'm just asking.
Every 2 weeks.
Every 2 weeks. Okay.
Yes, sir.
And what have been the results of those?
It's all my levels have been going down.
You sure?
What are the results of those?
I'm not 100% positive, sir.
Nobody's told you about them?
They just tell me the levels have been going down.
Really?
Been going up.
Don, do you know anything about the results of the?
I was furnished with a copy of this yesterday, which shows me that he's still testing positive, but the results have been going down. The most recent one did not show to the level that it was previously.
Yes. Doesn't matter.
I haven't been using any.
All right, that is all on this case.
This is where things start heating up. The defendant insists he hasn't used anything, yet the judge has documentation showing 6 consecutive positive cocaine tests, including the most recent patch collected just a week ago. Notice how the judge focuses on science, not emotion. Drug patches don't lie. They measure metabolites over time, and levels going up or down don't change the fact that the substance is present. This moment also shows a classic courtroom conflict. Defendants often blame environment, cross-contamination, or accidents. But in bond revocation hearings, the standard is simple. You test positive, you're in violation. What do you think? Is the judge being too harsh, or is he simply enforcing the rules?
I don't care what you have. You've got 6 positive tests here. The last one was a drug patch that was collected a week ago.
But I haven't been in 2 weeks.
I don't care what you are.
Yes, sir.
While you're not,
I'm not.
on my watch, you don't test positive for drugs. You've got six positive tests here for cocaine.
I can take a drug test right now.
Good for you. You failed the other
I
tests.
don't know how cocaine came up. I do not.
It must have been a mystical event, a miracle.
I'm so
But
serious.
this is science. You know how many, I wish I had $1 for everybody who says, I know I'm testing positive. I don't know how that got in my system.
But I'll put my right hands on the Bible, I swear.
You can write down, I've heard that one before. I swear to God, I know.
I stopped
I
smoking
know.
everything.
Every polygraph goes off in the city when you say that. No. Yeah. Just because levels go down, that's not, they're supposed to be 0. Nothing,
But
not a hint.
sir.
You've been testing positive on cocaine now since, let's see,
That's what I'm saying.
since June,
I don't
buddy.
understand how I can test
I know.
positive for cocaine.
But I'm gonna rely on science, not your
I
word.
understand.
Okay, all right,
I understand.
all right. What is this bond?
$30,000.
Yeah, your bond is revoked. You're gonna go to jail. Sorry, the rules are the rules. First thing, don't commit a crime. Illegal possession of cocaine is a crime. It's in your
Don't
system.
possess it. Never touch
It's
it.
in your system. You're possessing it. If you don't have to have it in your
Sir.
hand, sir, it's in your system. Don't interrupt the court when I'm trying to
Yes, sir.
talk. You're going to debate me?
No.
Really? You're testing positive on these tests 6 times in a row here. Every 2 weeks, 6 times. You're testing positive and you're going to debate? It's not a debate.
No debate. I just want to tell you.
Shame on you.
Possible circumstances. I work in a recording studio. I don't know what people do. If I ask them to touch it or any of that, it's not me using it. I would not use that drug.
Okay.
The most I've ever done is smoke marijuana. So, and I don't even do that anymore.
Sorry. You got cocaine in your system. How it gets in your system, I don't have to figure it out. I don't have to prove that. The tests that they're coming back are enough. You shouldn't be testing positive. Change jobs if that's what it is. Do something else, but you've tested positive 6 times. No one does that. That's a rare event here. My God, I get 2,500 cases a year for 18 years. This is a rare event. And you can't attribute it to a miraculous event. It's not a miraculous event. It's science. Your bond is revoked.
Yes, sir.
You're in custody. Mr. Arline is present with his attorney, Mr. Rennick, and the state's attorney does. The defendant waive a formal reading, of the indictment and the arraignment. Can we proceed in summary?
Yes, Your Honor. And just going on the
Prior convictions.
going on the first paragraph,
Kind of getting a bargain deal here there, buddy. We go back to 2011, you know, 2007, 1994, 1992, 33 years of felonies, including
This transition into the
Committed
burglary case shows a completely
second
different
degree felony
dynamic,
of
but an
burglary
equally
of a
serious one.
habitation.
The judge
Paragraph
reviews a rap
1
sheet that
states
spans more than 3
you
decades,
committed
with
the
multiple
burglary
burglary
without the effective
convictions,
consent
probation,
of
revocations,
Rebecca
and
Gasper,
repeated
the
felony
owner, with
conduct.
intent
When the
to commit
history is
theft and
this long,
assault.
judges
And
look for
paragraph
patterns,
2
and this
states
defendant's pattern is
you
clear.
committed
Repeated
burglary of
opportunities
habitation.
followed by repeated violations.
You understand what
Also,
you're charged
notice
with
the judge's tone.
with that
This
confusion.
is someone who has
So,
seen
it's a
thousands of
second degree
cases and
felony if
knows when a
convicted.
defendant is
Again,
getting a
you're
bargain
facing
deal.
no less than
Here,
2 no
a
more than
second
20
degree
years
felony with a
confinement in
set
prison
tenure
and a fine
agreement is
up
actually
to
far lighter than the
$10,000
maximum penalty available
can
under
be
Texas law.
assessed.
Let me
Do you
ask you,
understand,
in a
sir?
case with 33 years of
An
priors, would
agreement's
you
been
offer a
reached, you
plea
would be
deal
pleading
or
guilty,
push for
sentenced to
maximum
10
time?
years and 3 prior burglary convictions of habitations. And so we have another burglary of a habitation. 25 CR 107 is now called. And Mr. Orline is present again with his attorney, Mr. Rennick. In summary, paragraph 1, this is very confusing, the worded indictment. I've done this for 40 years, and this one was an odd one. Okay. It alleges in the indictment that on or about January 17th, 2025, Jefferson County, Texas, you committed the second degree felony of burglary of a habitation. Paragraph 1 states you committed the burglary without the effective consent of Rebecca Gasper, the owner, with intent to commit theft and assault. And paragraph 2 states you committed burglary of a habitation. You understand what you're charged with that confusion. So it's a second degree felony if convicted. Again, you're facing no less than 2 no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand, sir? Yes. An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement as well? Another case, 25 CCR 440 would be dismissed as consideration in this agreement. If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
I'm going to show you what's marked as States Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes.
States Exhibit 1,
No objection.
tendered into evidence without objection, is admitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. The indictments read to you, and you've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is way.
Yes, Your Honor.
I'm going to follow this agreement then, sir, and make the following findings: that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of burglary of a habitation. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You understand what has happened today, sir?
Yes.
All right. You're going to be taken into custody, as you understand. Anything else?
No, Your Honor.
In
And
prison,
that brings
is that
both
your
cases to a
understanding?
close. In the
of the
first,
agreement
the
as
defendant's
well.
repeated
Another
positive drug
case,
tests outweighed every
25
explanation he
CCR
offered, leading to
440
an
would
immediate
be
bond
dismissed
revocation. In the second, a defendant
consideration
with a long
in
and
this
complicated
agreement.
criminal history accepted a
If I
10-year
follow this
sentence as
agreement,
part
you
of a
have no right
negotiated
of
plea,
appeal.
a
Do you
deal
understand?
likely influenced
Yes.
by
How
decades
do you
of prior
plead to this?
convictions and
Okay,
the
sir,
seriousness
guilty or
of the
not
burglary
guilty?
charge.
Guilty.
These moments
Are
show
you
how the
pleading
justice
guilty
system balances facts,
voluntarily? That is
history,
on
and
your own
accountability, and how
free
quickly a
will, and
judge must
because
make
you are
decisions that
guilty.
change lives.
Yes.
If you found
That
this
shows it's
breakdown
marked
as
as
eye-opening
States
as we
Exhibit
did,
1
make
here.
sure to
Did you sign
LIKE,
that
leave your
document
thoughts in the comments,
voluntarily?
and
Understand it?
subscribe for more
Discussing with
intense
your
courtroom
attorney or the
analysis.
content